I guess we can get started. I know some of you have trains to catch. So welcome to the final panel of the day. I hope you all are not too sleepy at this point of time. So after a day of a lot of, international and regional perspectives, we now move to our final session of the day, which is on the national constitutional perspective, UK and comparative lenses. You hear on the UK, but also on Netherlands and Australia, and how these all topics even play out in the national domain. Our first speaker for this session is Dr. Stuart Wallace, who's an associate professor at the University of Leeds, and he will be presenting on Are Human Rights Protections Even Universal in the UK? Stuart, over to you.
Thank you very much, and thank you to all of the organizers for this amazing conference. Sorry, people able to hear me okay? Yeah, thank you to everyone for having me and for organizing this amazing conference. So as Amal said, I was going to look at whether or not universal human rights are actually present in the UK, and also try and tie it to a wider question of this idea of cultural relativism and how we're seeing something very unusual happening within the UK. So the presentation is going to start off by taking kind of a tour of the entirety of the UK, kind of looking at the human rights protection landscape that they have, look at how that is becoming increasingly fragmented, and to look at how the central institutions, the Westminster government, the UK Supreme Court, are largely holding back progressive rights development within the UK, and how this is quite an odd thing to happen, in my view, at any rate. And I definitely welcome some feedback about your own opinions specifically on that. So to start off with the tour, we'll go to Northern Ireland, and Kadia spoke something about this yesterday. So I don't necessarily need to go into the same material, but suffice to say that the situation in Northern Ireland is perhaps the most extreme example of fragmentation that we see across the UK because of the Windsor Framework. And under the Windsor Framework, effectively, Article 2 of the framework requires that the UK ensure that there is no diminution of rights, safeguards, and equality of opportunity as set out in the Good Friday Agreement, resulting from Northern Ireland's withdrawal from the EU. So in effect, the UK is not allowed to reduce the human rights protections enjoyed by the people in Northern Ireland to the situation that existed prior to Brexit. So the EU is a bit like Hotel California in Northern Ireland, in that you can kind of check out anytime you like, but you can't really leave. So in principle, the impact of this should be relatively limited because of the case of Rees-Buck, a Court of Appeal case in the UK, where they outlined effectively the conditions that are required before Article 2 of the Windsor Framework actually applies. So as you can see, there's lots and lots of conditions that attach to it. So in principle, at least, you might say that the impact of it may be relatively limited. And I think on some level, perhaps the UK government expected the impact of it to be more limited than it has been. But it is having an impact now as a result of a couple of different cases, in particular the case of Reid Dillon, which related to the Northern Ireland Troubles Legacy and Reconciliation Act of 2023. And what it means effectively is that when this case came before the courts, the court held that there was a case taken under the Windsor Framework and under the Human Rights Act. They issued declarations of incompatibility in relation to several sections of the Northern Ireland Troubles Act, but they also used the Windsor Framework. And the consequence of using the Windsor Framework was that the Northern Ireland, parts of the Northern Ireland Act were disapplied in Northern Ireland. So effectively, the ghost of Factor Tame is continuing to haunt Northern Ireland in many respects. So it's not just in terms of the content of the law that we're seeing differences, in the sense that EU law continues to have a significant effect within Northern Ireland, but also on the remedial side of things, because if you look at the remedial side of things, the rest of the UK can only utilise directly declarations of incompatibility under the Human Rights Act, whereas in Northern Ireland, they have something which is akin to a strong power of constitutional review that is, much more powerful by disapplying the law in that area than a declaration of incompatibility ever could be. And as well as that, we've seen the disapplication of parts of the Illegal Migration Act, again, only in Northern Ireland. Now, I will note that the Reed Dillon case is on appeal to the Supreme Court, so there could be a change in this, and the case has already been heard, so we're still awaiting the judgment. But as it stands at this moment in time, the people in Northern Ireland enjoy a much higher level of human rights protection through EU law and much stronger remedies than the rest of the UK. That's ultimately the upshot of this. So that's the first aspect of fragmentation. The second one in our tour is to have a look at Scotland. Now, there's different issues that are causing fragmentation here and differences between the human rights obligations in the rest of the UK. And this is essentially down to policy choices that are being made by the Scottish government. And they are essentially coming up with policy choices to enhance human rights protection, specifically in Scotland. And this relates in particular to the incorporation of the UN Convention on the Rights of the Child, which we saw in 2024. Now, I'll come back to some of the case law that surrounded this, but they have successfully implemented that legislation now in Northern Ireland as of 2024. So children's rights are actionable in a different way in Scotland than they are in the rest of the UK. And the Scottish government has repeatedly stated its intention to take a maximalist approach to the incorporation of treaties, and an intention as well to incorporate other treaties through their legislative powers. So they are planning to introduce a human rights bill for Scotland, which would incorporate the International Covenant on Economic, Social and Cultural Rights. It would incorporate CERD, it would incorporate CEDAW, and the CRPD as well. And what's really interesting about the proposals to do this legislation is that it would be really transformative stuff in the sense of how it's going about this incorporation, because it will introduce compliance duties on public authorities similar to Section 6 related directly to these treaties. They're going to have a process to establish minimum core obligations in the context of economic, social and cultural rights. They also have proposals to take direct account of treaty bodies' recommendations, general comments into the legal system of Scotland, as well as introducing effective remedies. So from that perspective, there's much more, I guess it's much more consequential the way that they're going about proposing to incorporate these treaties at any rate. Than in other aspects that we have seen, or in other ways that we've seen treaties incorporated in the past. So from that perspective, Scotland is on its own trajectory in that respect. The situation in Wales is a little bit more conflicted, and this is largely down to the way that the devolution setup worked in Wales. So they've only relatively recently switched from a conferred powers model to a reserved powers model. So this means, in effect, that Wales recently got more powers to legislate than it historically had. So as a result of that, their approach to incorporation of human rights standards has been, more recent, less coordinated. Having said that, they have had indirect incorporation of several things. So to the extent that they could use their legislative powers, they have to incorporate aspects of the CRPD and the Convention on the Rights of the Child, to have due regard to those in the context of different legislative measures that they introduced. And they have also, as of 2021, I think it was, introduced plans to incorporate the CRPD and the CEDAW as well. So again, we're seeing this trajectory across devolved institutions, devolved governments, away from what's happening across the rest of the UK, where they're going in their own direction in terms of incorporating and adopting international human rights treaties and bringing them
within their legislative schemes. So the levels of human rights protection are varying depending on the location of the UK that you are in. And this causes a few different problems. And in particular, what we're starting to see is a big pushback that is happening within the central institutions of government. And that's happening in a few different ways. So devolution, just to give a brief explainer, it confers most of the powers on the devolved authorities, but it tends to reserve some of them to central government. Very different system to federalism, for example, which many of the European colleagues among us will be familiar with. But for example, legislation on equal opportunities is a reserved power. Legislation on the conduct of international relations also remains a reserved power. And as a result of this, incorporating treaties tends to cut across both devolved powers and reserve powers. So it makes it quite complicated in some respects to implement this legislation. And as a result of that, what we're starting to see is the Westminster government and the central authorities of the state starting to use checks on devolution that they have in their arsenal to stop these deviations or these changes in human rights law in other places. So they have two main things in their arsenal. First of all, we can use the example of the Scotland Act. So Section 33 means that law officers can refer a question of whether a bill has been passed by the Scottish Parliament within their competence. So if, for example, they tried to pass legislation related to equal opportunities, which is a reserve power, that could be potentially called in or challenged on the basis that it is a reserve power and that Scotland doesn't have it. And that they can't legislate in that field. The second area where they have this is what's called a Section 35 order. So the central government can effectively prevent the promulgation of a bill where the legislation makes modifications of the law as it applies to reserved matters and would have an adverse effect on reserved matters. Now, in terms of how these powers are actually being used, we saw the first one used in the context of the previous iteration of the UN Convention on the Rights of the Child bill. So essentially, Scotland had a go at incorporating the UN Convention on the Rights of the Child previously, and that was challenged by the law officers within the UK courts. And the reason why was because the way that they went about incorporating it, according to the law officers at any rate, exceeded the powers that Scotland had. So there was a strike down power within the legislation, the proposed legislation, that would allow Scottish courts to strike down parts of UK acts insofar as they related to areas of devolved competence that conflicted with the Convention on the Rights of the Child. There was also an interpretive duty in the legislation that meant that UK legislation had to be interpreted or read to give effect so that it was compatible with the relevant provisions of the CRC. That was challenged, and the Supreme Court held that Scotland couldn't pass the bill in that form. They said that this by allowing the existing legislation to remain in force unamended, that was one way in which the central government exercised its power to make laws for Scotland, and making the continuation of the in force of the acts of the UK Parliament conditional on this was not consistent with the powers that Scotland had. So as a result of this, Scotland went back to the drawing board with this bill and came up with a different solution. Now, what's interesting about this is that, and one of the key problems with it is it impacts the way that the devolved institutions can transmit their powers to other institutions. So it would be perfectly within the power of the devolved institutions, like the devolved legislature in Scotland, for example, to strike down aspects of UK law that they wanted to, but they couldn't pass on that power to the courts. So this limits what they can do in terms of incorporation and the way that they go about incorporating treaties within the devolved settlement. A second aspect of it happened relatively recently in relation to the Gender Recognition Reform Bill in Scotland, where Section 35 order was used to prevent the promulgation of that bill. And essentially, Scotland was trying to create a more permissive environment for gender recognition and a better situation for people, transgender people and transgender rights. And effectively, the central government shoved that down. And they said that it would have impacted on reserved matters of equal opportunities. So from this perspective, we can see this broader pattern the central government holding back the devolved institutions from doing these things. And I think what's interesting about this is when we look at it, and when we look typically what happens in these situations, it isn't the way that it's happening in the UK. And I've tried to look at this by applying the lens of cultural relativism, and this is something that I would definitely welcome feedback on. But when we look at the idea of cultural relativism, in a nutshell, it's the idea that all rights are culturally determined, and because cultures vary over time, and they have different standards and different what they think is right or wrong, there's no scope for universal standards, effectively. Now, normally, we see a universal standard that is established centrally, for example, through a treaty or a treaty body, and then the deviation happens at a local level. So that is predicated then on a cultural difference. So my all-time favorite example of this is Tyra versus the UK, where the people of the Isle of Man tried to justify keeping corporal punishment when it had been abandoned in the rest of the UK. And I'm quoting directly from the judgment here, because it would act as a deterrent to hooligans visiting the island as tourists. So this is an example of cultural relativism in practice. We all abandon corporal punishment, but the Isle of Man wants to keep it for tourists. So what's really odd about the situation in the UK is that this process is being reversed. So instead of the deviation happening within the local area, what we're seeing is the local area is actually trying to uphold the universal standards. So within Northern Ireland, for example, they're trying to apply Europe-wide standards and maintain Europe-wide standards through the Windsor Framework, for example, but the central government is deviating from those standards by, first of all, introducing legislation like the Illegal Migration Act, like the Northern Ireland Troubles Act, and also through litigation by appealing the Dillon judgment and challenging the capacity of the UK courts to actually, or the Northern Ireland authorities and the Northern Irish courts, to actually impose this and to create these changes. And then the same thing is happening in the context of Scotland. We see Scotland trying to implement universal standards in the form of children's rights by incorporating the UNCRC convention, for example, but the central government deviating from that. And it's been described as a provocatively regressive approach by Busby. And I think this is really true in the sense that they had other options to take here, right? So the UK could have introduced legislation. It's already a party to the treaty. They could have introduced legislation across the UK to implement and incorporate the UNCRC, but they didn't. They just stopped Scotland from doing it. That was the option that they took. And one of the consequences of this is that it's having a real chilling effect on the government's confidence in Scotland to incorporate treaties within the devolution framework. So they've really put the brakes on taking further steps to introduce a Scottish Bill of Rights, for example. So we see refusing to incorporate a UK-wide treaty, openly challenging the devolved incorporation through the UNCRC bill, challenges at the Supreme Court and elsewhere, and in general having this chilling effect on the devolved institutions trying to develop or enhance human rights protections or adopt universal standards at their local level. Okay, so to conclude very quickly, we're seeing an increasingly fragmented rights protection landscape across the UK in Northern Ireland, Wales, and Scotland, particularly evident in Northern Ireland. We see the Westminster government taking a provocatively regressive approach to rights protection through legislation, litigation, and the management of devolution, and not promoting universality, and instead trying to create disparity, trying to create this kind of fragmented system that we're seeing. And in some respects, I think this is really a weird case of reverse cultural relativism, where instead of the regions or local areas deviating, we're seeing the center is actually the one that's causing the deviating behavior. And I think that's a really interesting, weird thing to happen. But that's it.
Thank you, Stuart. That was a very interesting, albeit gloomy presentation. And with that, a very nice juxtaposition is our next paper by Jasper Krommendijk from, he's a professor of human rights law at Radboud University in the Netherlands. And Jasper is going to talk about his paper's titled Denial or Dutifulness, Dutch Courts and Decisions of International Human Rights Courts and Committees. And one of the things he wants to argue in this paper is that a lot of these gloomy accounts are quite exaggerated, and we should not be doing that too much. So over to you, Jasper.
Yeah, thank you very much, Amal, and thank you to the organizers for having me here. I'll try to give a bit of optimism just before the weekend and in this last panel. So indeed, my work is on the Netherlands, and perhaps before I delve into the paper, to give you a bit of context. Perhaps it's good to give you a bit of context of the Netherlands. Well, we're, as you might know, quite a monist country, so treaties have quite a favorable reception, and that also has to do with the fact that constitutional review is precluded. But we have treaty review in our country, which also means that norms that are directly effective can be relied upon before courts and can also be used by courts to squash legislation. I think a good example of the ECHR having a lot of impact is the Adaena case decided by the Supreme Court. So that looks quite nice, but hearing also these stories on the UK, it's fair to say that we see, let's say, leaving aside our judiciary from the governmental front, I think primarily politics, increasing criticism on the role of courts, the notion of the rule of law, and also more and more proposals to withdraw from treaties, including the ECHR. So some parties, primarily at the right, propose that. So this is very shortly about the Dutch context. Let me move. That's this one. Oh, it's that one now. So in my project, I focused on the judiciary. I took indeed this backlash phenomenon as a starting point. And I think in the light of this backlash with national courts as important compliance partners, my question was then, to what extent do they rely on decisions from international courts, international human rights courts and treaty bodies? So how, when, and why? And this project, what I did was doing a doctrinal legal analysis, complementing that with interviews with judges and advocate generals from the highest Dutch courts. And well, also following my introduction, the Dutch context, I think the Netherlands isn't sort of most likely case in which you expect these international decisions to have quite some impact. Well, just to immediately, let's say, start with the findings. So there is reason for optimism if we look at, let's say, the Strasbourg court. I found less engagement with, let's say, decisions from UN human rights treaty bodies. And also, I also looked at the European Committee on Social Rights. But focusing on the positive, I really saw judges talking about the court and their judgments as belonging to our DNA, belonging to the daily fare of legal practice, and they really engaged with the decisions of the Strasbourg court extensively. So I looked at 3 years of case law, and I found more than 400 judgments in which, let's say, the Strasbourg court is explicitly referred to with extensive citations of judgments. And that is less so for, let's say, the UN human rights treaty bodies. Well, you see, and I'll be very short about that, but there are differences in way of engagement. So you see in these extensive substantive engagements, short and passing references, but I was also particularly interested in what I call so-called silent judgments, in which the court is not relying, not explicitly citing treaty bodies or the Strasbourg court. Well, very briefly on my methodology, I looked at criticism in professional legal journals as to the non-reliance on Strasbourg. And I looked at how experts, for example, said, well, the court should have relied on Strasbourg. Well, this was some sort of preparatory work that I also used in my interviews, even though judges are generally quite reluctant to speak about individual cases. I try to, let's say, still after having obtained the permission to interview them, to prop them with such cases. So you see different forms of engagement, and I describe various examples in my paper. I think it's also important to note that there's, aside from citing a judgment or non-citing, it's important to acknowledge that courts might sometimes also, let's say, deliberate and discuss a case, even though they're not accounting for that in the judgment. So that is also something that I, let's say, try to reveal via interviews. And that was also then acknowledged by interviewees. Well, I'm especially interested because I think this could really help us and also could also help other countries. What are then the reasons for this engagement? So what I did was on the basis of literature about, let's say, human rights effectiveness and compliance, but also EU law compliance and effectiveness. I distilled 7, let's say, explanations based on theories about, let's say, engagement and compliance. So this is something, if you're interested, that I wrote already a few years ago for a book edited by Rachel Murray and Deborah Long. There I discussed these 7 theories. And now, well, this new project gave me the chance to reflect on the, let's say, the validity of these theoretical explanations. So what did I see in my study on the Netherlands? Well, I think it's important to mention that Dutch courts are generally quite pragmatic and practical in their decision whether to rely on and cite these international decisions. But they're also, well, very legal in the sense that they argue, well, bindingness matters. So we all know that decisions from human rights treaty bodies are legally non-binding. Well, for Strasbourg, res interpretata effect, de facto bindingness, and that is also what Dutch judges told me and what you see in the judgments. So they find it quite natural. They don't question that there is this bindingness and that they're bound to follow the judgments. So you won't see very critical judgments of Dutch courts, downplaying the bindingness of explicitly saying, well, we don't have to follow this because we don't like it. What I also found in my research, especially if you look to political science literature on courts, you see that they tend to exaggerate or portray courts as strategic actors using external laws as a reason to justify a certain decision vis-a-vis the legislature or executive. So my question here was also, do you rely on Strasbourg judgments as a way to, let's say, support towards the legislator when you determine that a law is contrary to the ECHR? And in my interviews, I saw this dynamic in another project when I looked at EU references to the Court of Justice by national courts. There you saw indeed courts referring cases to Luxembourg to get some support from Luxembourg. But in terms of, let's say, citing Strasbourg or not, this is not a dynamic I found applicable. I also engaged with the identity thesis. This was developed in the 1990s by Anna-Marie Slaughter, amongst many others, I think against the optimistic days of the fall of the Berlin Wall and the end of communism. This idea that there is this common identity of judges as being, let's say, worldly judges. So there's this transnational idea of we all want to bring human rights forward. So I put that identity thesis, this shared identity, also in interviews to the judges, and well, this didn't really resonate. So they really said, well, we're quite pragmatic, so we avoid these air castles, as one interviewee put it. We tend to avoid that. So it's not that we cite or engage with Strasbourg decisions because we feel, let's say, that there is this identity with other European judges. So what I also said, and that also relates to pragmatical considerations, that, well, you engage with decisions because the parties rely on it, they invoke it, so we simply have to respond to that. So legal and practical considerations are dominant, and the other explanations are not very relevant. So another explanation that I think is very interesting, especially in terms of backlash to examine, is and also that also helps explain the difference between the Strasbourg Court and the UN treaty bodies in the extent of reliance, is that, well, most interviewees would say, well, the European Court of Human Rights is doing a good job. Well, they produce nice judgments. We're sometimes critical about, let's say, the casuistic nature of the judgments and the fact that there are many judgments and that HUDOC is so inaccessible and that you can't always know what a particular line of the Strasbourg Court is. So we really have to ask 10 experts to see what the particular line is. That makes it sometimes difficult, but they're not questioning the legitimacy. Whereas, well, the views of my interviewees about the UN bodies are slightly more negative, and most of them, or some of them, didn't even know about it, and they spoke about it in quite a negative way. So the Strasbourg Court for the Dutch judiciary is a clear judicial authority. Another, let's say, related explanation is the notion of capacity, and this very much relates to, let's say, knowledge, but also supporting staff. I think in comparative terms, the Dutch judiciary, especially the highest courts, are doing quite well in terms of the support staff, and they also notice that themselves in comparison with lower courts, but also courts in some other member states. So this is also necessary if you want to rely and cite a court. You really want to cite the newest precedent. So you should be sure that this is really the state of the art in terms of the current stance of the jurisprudence. So you should know everything. And well, also here you see this difference between Strasbourg and UN human rights treaty bodies, where, well, you see this quote saying, well, don't we have various committees? Well, I don't really know one. Whereas for the Strasbourg court, oh gosh, I don't have a quote. They really know what is going on, or they follow it, or at least the supporting staff is following it. So these quotes are still on the UN treaty bodies, but also, well, a bit on European jurisprudence in general, the complexity of keeping track of all these developments. I think in the multi-level legal order that we're in today, it's very difficult for national courts to follow it. So capacity is really important. Well, another explanation that I focused on is personality. There are two, let's say, variants of this. Well, one frames it very much in terms of personal interest, career, prestige. Well, that didn't resonate either. And I think it's also fair to say that this does not really apply, at least in the context of the Netherlands. But what really matters, and this is, I think, not a very, let's say, surprising finding, but we just really see that the background of judges and their expertise really matters. So you see judges with an academic background more interested in engaging with case law, but also old style judges are also more, let's say, focused on the ECHR. So I also interviewed some judges at the highest administrative court with a background in Luxembourg. So they have been an agent before the Luxembourg court. And they reasoned very much, well, if there's EU law and it's applicable, we first have to go to the charter. From a legal point of view, that's also the correct perspective. So they're more focused on Luxembourg than Strasbourg. So they even mentioned that there is some sort of, not a fight, but at least some sort of internal disagreement between judges. So educational and professional background matters. Well, this is a bit more on the identity thesis. So I really try to get them to reflect on that. And here you see on the slide, I think I've not the time to go over this, but this whole identity thesis did not resonate. Well, where does that bring me? So looking at the 7 explanations, explaining the difference between, well, what I say dutifulness, so the Dutch judiciary relying on engaging with Strasbourg, versus what I would say denial of decisions of UN bodies, but also the European Committee, so non-binding decisions. Well, bindingness really matters, and that also explains the spiral going downwards or upwards in the case of Strasbourg. If it's binding, well, parties also favor it and rely on, well, Strasbourg instead of the UN. Also when, well, the legitimacy is disputed or stronger and there is staff. So all these factors together are mutually reinforcing. In the case of Strasbourg, they really help or favor engagement. And for the UN, well, this works the other way around. So in my research, I didn't find much support for the other 3 explanations. But I think, let's say, closing with then the note of optimism, at least if we focus on Strasbourg, I think at least my paper shows that the judiciary can still make a difference. And well, at least the views that the Dutch judges and staff and advocate generals do not question Strasbourg as such, I think it's a reason to be slightly optimistic. So thank you.
Thank you so much. Thank you so much, Jasper, both for the interesting presentation, but also for sticking really to time. Next, we have Naz, who's a PhD candidate at Maastricht University. Her presentation actually builds a little bit more on, I guess, Stuart's presentation and more complements that. But it's going to focus on the implementation of the European Court judgments in the UK and in UK's complicated devolved setup. So Naz, I know you're getting your slides ready, so take your time. Whenever you're ready, you can just go ahead.
I think shall we should.
Yeah, yes. This one?
No, this one. Yeah. Good afternoon, everyone. It's a great honor to present my research in this distinguished setting, and I would like to thank the organizers for this opportunity. This moment also has a special meaning for me because during my master's degree at the Queen Mary University of London, I submitted many of my essays in this building, and it's very nice to come back. And my PhD is about the execution of judgments. I'm exploring the execution system for the European Court of Human Rights judgments in the UK, in the Netherlands, and Croatia. But today I will discuss the implementation of judgments in the UK with a particular focus on the devolution context. This presentation is my part of my ongoing PhD, and I will appreciate your feedback in the end of my presentation. And I would like to start my presentation with the fundamental source of the execution obligation, Article 46 of the Convention. In simple terms, this provision means that a respondent state must comply with the court's adverse judgments. At first glance, this innovative provision appears straightforward because it establishes a clear legal obligation. But when we try to translate this obligation into national law in a concrete way, two fundamental questions arises. What does the term execution mean for a given judgment, and what is the nature of the party responsible for the execution of the adverse judgment? The first question is important for understanding the scope of the responsibility. Under Article 46 of the Convention, all judgments of the European Court of Human Rights are binding. However, the court usually identifies a problem, it declares a violation, but it does not say exactly how the state should fix it. That responsibility is left to national authorities. During my traineeship in the execution department of the European Court of Human Rights, I had a talk with a senior lawyer, and he shared an analogy to illustrate this point with me. It may not be the happiest example, but it explains the concept. He likened the European Court of Human Rights judgments to doctor's reports. A doctor might diagnose a patient with cancer, but the level of detail provided can vary. Some reports specify the type and the stage of cancer, while others simply state the diagnosis without further elaboration. However, even when a diagnosis is clear, doctors do not necessarily dictate the exact course of treatment. The question of whether medication, surgery, or radiotherapy should be pursued is left to the medical experts. In the European Convention system, similarly, the identification of measures to remedy a specific judgment is the task of member states under the supervision of the Committee of Ministers. And this brings me to my second question, which focuses on the who question. What is the nature of the party responsible for the execution of the adverse judgment? At the international level, the answer to the question is simply the states. At the national level, it is more complex because there might be many relevant domestic institutions and actors. In order to examine these, scholars developed an approach by disaggregating the state, looking separately at the judiciary, the executive, and legislatures. When we even look closely, there are often additional layers of authority within states, depending on their constitutional organizations. Those layers may include federal entities, province, cantons, devolved nations, or autonomous regions. Depending on the nature of the violation found by the court, these subnational actors may become the primary agents responsible for remedying the violation. After this general background, I would like to turn to the United Kingdom. Let me start with some statistics. Compared to other member states, the UK is actually a very good performer in implementing the court's judgments. According to recent figures, around 96 of the leading judgments against the UK have been closed by the Committee of Ministers. When I first saw this figure, I was quite surprised because, as we all know, when we follow the news or watch the Prime Minister's questions every Wednesday, we often hear a great deal of grumbling about the court judgments or even leaving from the convention system, as we all know. But the relationship has been well characterized by Professor Ziegler and her colleagues as a strained relationship. And yet, despite this rhetoric, the UK has maintained a strong record of implementation overall. Of course, this doesn't mean the picture is entirely positive. There have been examples of minimal execution of judgments. Currently, there are 12 pending cases under the supervision of the Committee of Ministers, and interestingly, 5 of them concern devolved nations. The most prominent examples include the Gafran case group and the Mekker versus the United Kingdom case group. The UK follows what I call an interactive system of execution. Once the European Court of Human Rights identify a violation, different governmental departments become involved in preparing action plan. And these documents are circulated among relevant ministries. And this internal circulation method has inspired other member states, such as Croatia also. And the most important feature of the UK system is the active involvement of the Westminster Parliament, in particular the Joint Committee on Human Rights, which not only provides scrutiny and recommendation to the governments, but its reports also serve an important accountability function, requesting for justification. The current devolved framework was established in 1998 through the respective devolution settlements, as we already listened, the Scotland Act, the Northern Ireland Act, and the Government of the Wales Act. And each of these acts define the scope of authority for the devolved governments and parliaments. And as a rule, that means that devolved parliaments can only pass laws in devolved areas. The CELI Convention further stipulates that UK parliaments will not normally legislate with regard to devolved matters except with the agreement of devolved legislature. And the Westminster Parliament remains responsible for many issues related to adverse judgments of the Strasbourg Court against the UK, notably in areas such as defense and national security, foreign policy, immigration, and citizenship. And devolved parliaments also empowered to legislate on a wide range of areas, including justice, health, education, transport, environment, land distribution, and housing. The overlap of these responsibilities, particularly in areas that may involve human rights issues, can raise complexities regarding the execution of judgments within the multi-level governance structure of the UK. Today, I will focus on 2 situations. I deliberately selected examples that represent outliers because I believe that in the execution process, if a member state can resolve its most complex cases, it can resolve the others much more easily. And the first situation concerns cases where devolved institutions have pushed for stronger human rights protection in the execution process. And the second situation involves cases where they have struggled to carry out necessary reforms, often due to internal political or structural challenges. For the first situation, I will take as an example of the judgment of Hurst versus United Kingdom. This case is perhaps one of the most debated judgments concerning the UK. But fortunately, just last month, the European Court of Human Rights gave us an excuse to speak more thanks to horror judgment. In Hearst and its subsequent pilot judgments, the European Court of Human Rights identified that the blanket ban on prisoners' voting rights breached the convention. Many scholars have described the UK's response to Hearst as an example of minimal execution, since the measures adopted were extremely limited. In 2018, the Committee of Ministers decided to close its supervision of the case. However, the political debate on prisoner voting rights in the UK has continued. I will not discuss the extent of measures taken or whether the European Court of Human Rights overstepped its role, but I will discuss what happened after the Hearst in the devolved nations, because when it comes to devolved nations, the situation becomes more complex. The respective establishment agreements, as I mentioned, set a minimum level of human rights protection for devolved nations, and devolved actors can always go beyond these arrangements in line with local contextual requirements, provided the matter at hand falls within their competence. Even in the post-execution process, the devolved structure can provide greater protection. The Hearst case provides a useful illustration of these broader reforms. Despite the Committee of Ministers closure decision in 2018, the case indirect influence continued to be felt in Scotland, where justice and prisons are devolved matters under its devolution agreements. In 2020, Scottish Parliament legislated in this area, extending voting rights to Scottish prisoners who are ordinary resident in Scotland and serving a sentence of less than 12 months. Since then, these prisoners have been eligible to vote in Scottish Parliament as well as local and national election. This legislative move can be considered a significant shift in how Scotland addresses the issues raised by the Hearst judgment. However, a problem comes from the different levels of protection operating within the same country. People who live in a devolved nation, such as Scotland, may have broader human rights than their counterparts in other parts of the UK. One may say that as long as there is a baseline level of protection, that is sufficient within the convention system. Government agencies may well consider the issue in the same way, but from the individual's perspective, this approach is deeply problematic because it means that people do not benefit equally from the protection offered by the European Court of Human Rights. Let me now turn to I will skip Wales, but yeah. Let me now turn to the second station, where a devolved nation is unable to execute a judgment because of its internal challenges. These internal challenges may include a lack of financial capacity, an inability to form a functioning parliament or government, or a lack of political will. In the UK context, financial limitations are not usually the main cause of delayed or non-execution. However, in other countries, for example, in the Caribbean parts of the Kingdom of the Netherlands, financial constraints have indeed made execution extremely difficult. In the UK, political problems can present challenges to implementation. In Gafran versus the United Kingdom, the European Court of Human Rights ruled that indefinite detention of biometric data in Northern Ireland without reference to seriousness of the offence or the possibility of review constitute a violation of Article 8. The case has been pending before the Committee of Ministers for several years. Implementation has progressed in many parts of the UK, but Northern Ireland still requires significant legal amendments. The delay in Northern Ireland's implementation of the Gafran judgment is mainly linked to its constitutional and institutional structure. Because the Northern Ireland government operates on a power-sharing model, the functioning of its institutions depends on cooperation between different political parties. When one party withdraws from the coalition, as has happened several times, the devolved government cannot operate and no legislation can be adopted. As a result, for long periods, Northern Ireland has had no functioning government, which directly delayed the execution of judgments. The Joint Committee on Human Rights has also noted that weak coordination between the UK government and the Northern Ireland executive further contributed to these delays. The UK Parliament could have acted to resolve the issue, but it chose also not to intervene, mainly to respect Northern Ireland's devolved powers under the Stockholm Convention and the Good Friday Agreement. This leads to a question: what role should the Minister of Justice play when a devolved nation faces such difficulties? The ministry operates at state level, but it must navigate both legal responsibilities under the convention and political sensitivities related to devolution, a balance that is often difficult to maintain. Turning to some early conclusion of my research and the direction of my ongoing research, it's important to recognize that the particular political difficulties can arise within devolved nations, where internal dynamics and power-sharing arrangements may complicate the execution of judgments. And constitutional design has emerged as a key factor in understanding these challenges. And communication between central and devolved authorities is important to ensure consistent and timely implementation across all parts of the state. In the next part of my research, I plan to focus on the role of devolved parliamentary committees in this communication, along with the Joint Committee on Human Rights. Thank you very much for your attention.
Thank you so much, Naz. And I hope you all have still some energy left. We're going to move to the last presentation of the day and the conference, which is going to be given by Adaena Sinclair-Blakemore. Adaena works in this building at the British Institute of International and Comparative Law as a researcher in public international law and human rights. And ending on a little more positive note, Adaena will focus on how the ECHR has impacted decision-making in Australia, which otherwise is a jurisdiction very not supportive of incorporating international law in its interpretation. And would perhaps conclude with how the ECHR, while we're hearing a lot of negative and gloomy perspectives, is actually contributing to resilience across the European borders. So Adaena, over to you.
Thank you. I might need a microphone. Okay, thank you. So yes, my presentation is going to be on a more optimistic note, which I think is a good way to finish this conference. So naturally, over the past 2 days, we've focused on the influence of the convention in member states. But one of the questions that has always interested me as someone who's not from a member state is, does the ECHR have an influence beyond Europe? And so I'm an Australian qualified lawyer. I was educated and qualified in Australia, but then I spent a year working at the court, which sort of changed the direction of my career towards European human rights law, which is why I'm also working here at BICL. So that's where the impetus for my research has come from. So I'm going to focus on the influence of the ECHR on constitutional rights in Australia. Don't worry, it's not going to be a lecture on Australian constitutional law because I don't think anyone needs that or wants that right now. So I'm going to keep it at a pretty high level. Okay, so to give you some background, so human rights protections in Australia are quite fragmented, which I think is one of the reasons why Australia is a very compelling case study for this. So when we look at human rights in Australia, Australia is party to a number of the big UN multilateral conventions, but it's not part of any regional system. There's no constitutional Bill of Rights, although the Constitution does protect some rights, such as the acquisition of property from the state or freedom of religion. There's no Federal Human Rights Act, although there is an ongoing push for one. Only 2 states and 1 territory have human rights legislation in place. And there are certain other acts, such as the Sex Discrimination Act or the Racial Discrimination Act, that protect rights. But generally, it's a bit of a mixed bag approach to rights protection through the Constitution, the common law, and various pieces of legislation. But the degree of rights protection is going to vary depending on which state one lives in. Hold the microphone. Okay. Okay, so the other reason why I think Australia is a good case study is, as you can see from this slide, and as was said in the introduction to this talk, international law is generally viewed with a lot of scepticism by Australian courts, particularly the High Court, which is the highest court in the hierarchy. So it's the equivalent to the Supreme Court or the Constitutional Court in other jurisdictions. Now, when looking at international law as an interpretive aid when it comes to statutes or the common law, the general view is that international law can be used to interpret these principles. But when it comes to the Constitution, that view is very different. So there's generally a very sharp divide in judicial ideology as to whether international law can have any influence on the development of constitutional principles. So it's been international law in constitutional interpretation has been described as heretical by one judge. And I think my favourite quote by Hilary Charlesworth, who is now the Australian judge on the ICJ, she described the Australian approach to international law as a Trojan horse importing dangerous foreign values. And I think that really sums up the Australian approach to international law when it comes to interpreting the Constitution. So bearing that background in mind, it was actually when I was at the ECHR, I did a quick search of case law in Australia, and I thought to myself, I wonder if an Australian court has ever cited the convention or one of the court's cases. I thought the answer would be no. So I was very surprised when I did do these searches that 71 judgments of the High Court since the entry into force of the convention have cited the convention or the case law. That is quite a small percentage of overall judgments. But I think what's particularly striking is that when you look at just constitutional cases in which apparently international law doesn't really have any influence, that number sits at 9%. And I think that's quite a high number when you're thinking about Australia not being a member state, generally having no reason to look to the ECHR, and the court being very ambivalent towards the use of international treaties as well. So naturally, I started looking at why this might be the case and which types of judgments the High Court has looked to. So I'm just going to give two examples. So the first one, which is the case of Roach. So this case raised an issue which is a blanket ban on all prisoners from voting in state and federal elections unconstitutional. Now, we've already talked about Hearst today, but there was generally very little guidance for the High Court on this question from foreign jurisdictions. And so the court looked to the judgment of Hearst, and the majority judgment in that case, the majority in the Australian court took Hearst as instructive and said that the analysis was incredibly valuable for the Australian court. And although it wasn't binding or directly applicable to the Australian context, they did end up adopting the proportionality analysis that was used in Hearst, and they struck down this legislation on the basis of Hearst. So that's one example of where one of the European court judgments has been particularly influential. The second example is the case of McCloy. And so this was a case which raised various issues to do with political donations and laws that prohibited property developers from making political donations and imposed caps on political donations. So there's no freestanding right of freedom of speech or expression in Australia, and so it's an implied freedom in the Constitution. So the question for the court was, do these laws burden that freedom to such an extent that they're impermissible under the Constitution? And the High Court said no, that they were permissible. And in looking at this case, they turned to the jurisprudence under Article 10 of the ECHR. And even though they said that there's no freestanding right to freedom of speech, again, they found that the proportionality analysis under Article 10, they said it has evident utility, and again, that it was instructive. And they ended up having a wholesale adoption of the ECHR proportionality test under Article 10 into the Australian constitutional interpretation. Now, in both of these cases, there were strong dissenting opinions, and both of the dissents did talk extensively about how recourse shouldn't be made to the ECHR, that it's not binding, it has no influence, it came into force after the Constitution of Australia was adopted. So it's not necessarily this unanimous view that the ECHR should be used in constitutional interpretation, but the majority judgments were very strongly in favour of doing so. However, it is still somewhat unpredictable and ad hoc when the ECHR will be used. So I've looked at the cases that have cited the ECHR, and I think some of the factors that explain when it will be used, some of these might be self-evident. So for example, the case has to be raised by the parties. That's just part of the common law adversarial system. We also see that when there's similarity of wording between the different provisions, that's more likely to be a situation where an Australian court will turn to the ECHR. One of the more interesting points, I think, is that about 75% of the cases that the High Court of Australia has referred to have had the UK as a respondent state, which I think makes sense given the sort of historical and enduring connections between the Australian and UK legal systems. Another reason I think in the literature is the way that the Strasbourg court embraces the common law method of reasoning. So the Australian courts do look to other common law jurisdictions in constitutional interpretation, but I think that, and I realise this might be controversial to civil lawyers, but I think that the Strasbourg court does embrace many elements of common law reasoning. It has a very thin legislative basis, and it tends to reason its judgments from past cases rather than from the convention itself. And the other reason, or the other factor explaining this recourse to the ECHR is an individual judge's preference. But this is only the case sometimes, and I thought that this would probably be the most persuasive factor. So you have some judges who say that they will never make recourse to the convention because they have a far more originalist approach to constitutional interpretation. Then there are other judges who think that the Constitution should be read in light of international law, so they are more willing to make recourse to it. But most judges, I would say, sit somewhere in between. And when I've been looking at the various cases, there are some judges who in one case will look at the ECHR, but then in a subsequent case will say that it has no relevance. So I think there have to be other factors explaining that recourse. And then the factors that don't explain why the court might look to the ECHR include the constitutional issue or the provision in question. So it's been used in a wide range of cases concerning migration law, the implied freedom of speech, the limits on judicial power, limits on executive power. So it is used in a very wide range of cases. So I think one of the questions that arises naturally from this is there something particular about the Australian context that they turn to the ECHR, or is this also applicable in other non-member states? And this isn't something that I've looked at extensively yet, but I have found an interesting empirical study which looked at the use of non-domestic legal sources by the Canadian Supreme Court. And this study shows that the ECHR was the second most cited treaty by the court after the ICCPR. And the Strasbourg Court's case law made up 1/3 of the total number of the Supreme Court's international court citations. So I think there is a general, I think it can be said perhaps at a general level that other courts from non-member states are willing to look to the ECHR, and it clearly has some sort of persuasive authority in non-member states. But this is another question that I would like to look into more, perhaps looking more at countries like New Zealand and South Africa. So finally, what does this say about the ECHR? So I promised that I would end on an optimistic note, and I hope that this presentation has been somewhat optimistic. But I think when we talk about the ECHR, we naturally focus on the member states and the reluctance within some member states to accept judgments of the courts, the democratic backsliding that we're currently seeing. But I think when I look at the ECHR with my background, I think that it has a far more global influence than just in Europe. And I think that's also evident in when I was doing this research, I also looked at whether the American Convention or the African Charter on Human and People's Rights had ever been cited in an Australian court, and the answer was no. So I think you could put that down to perhaps a Eurocentric view that the Australian courts have taken, or perhaps the fact that the UK is a state party to the ECHR and the role that the UK influence still plays in Australia. But I think you could also say that more broadly, it shows a general level of respect and admiration for the Strasbourg court. And so I do think that you can say the convention is having a global influence and protecting human rights globally. So thank you.
Thank you so much, Adaena, and thanks everyone, A, for keeping it in time, and B, for these really interesting presentations. So we do have a couple of minutes. Actually, we have a good half an hour if you all want to continue, but we can take a couple of questions. Okay.
Yeah, so I have a question for Stuart, right? Yeah. I wasn't sure about your first name. So I was intrigued by the way you are framing your very instructive mapping through the lens of cultural relativism, because I wonder if it actually has the effect of eluding a number of very interesting questions that you could ask following your findings. Let me explain. So I think what's really interesting is at least that there seemed to be a correlation between a supportive approach and discourse towards implementing international human rights in devolved jurisdictions. But I couldn't see in your presentation a kind of a question mark about why. And I think it's too easy to say that it's just because, well, it's devolved. The question is, I think, how does a discourse, a kind of supportive discourse, develop within each and every devolved jurisdiction? What kind of set of actors, whether it's within this devolved government or outside of it, how is this ecosystem developing? And I think that this is, I mean, my hypothesis would be that this is inherently a political dynamic. It's not a cultural dynamic. And so I wonder if actually using cultural relativism does a disservice to your project, because it doesn't lay out a number of really interesting questions about how this more supportive approach is actually gaining traction. Thank you.
Yes, can I just follow that up as well? I'd make the same point. I mean, to what extent is the pushback, as you put it, against human rights implementation in Scotland and devolved countries, how much of that is not a pushback against human rights, but a pushback against devolution and the demands of devolution? The people who are pushing for human rights in Scotland are not really pushing for human rights at all. They're pushing for more and more devolution and eventually independence. It's no accident that the push for human rights, soi-disant, is actually has accelerated since the defeat of the the independence referendum. I think that there are more questions than answers in your presentation, I would argue. Can I also just make a comment about the Hearst case, which is that the Hearst case was not about prisoners' voting rights. It was about the blanket ban on prisoners' voting rights. And it's interesting that the man who actually led the case against Hearst was Lord Faulkner, who actually introduced the Human Rights Act. The Hearst case was seen as too much of a challenge to the national state because it demanded that all prisoners should have voting rights. And that was, to many people, a step too far.
Was first.
There you go.
thank you, because presentations were amazing. And although I have questions for lots of you, I'm going to prioritize two. One for Jasper, one for Nas. Jasper, could you elaborate a little bit more on the number of people, of judges that you interviewed and the type of judges? I mean, like throughout, I'm very interested in methodology and in empirical legal studies, and I wanted to know if you could elaborate a little bit on that. And if you think if that reflects beyond the Dutch experience, if you think these conclusions that you're presenting may be similar in other states in from the Council of Europe or even beyond. And Nas, I was actually wondering, so your conclusion in the end, well, not in the end, but do you think that if we had not a quasi-federal government, the other way around, sorry, still trying to frame it in my head, the question. Do you think that if there was a stronger political alignment between the regional, the devolved countries with Westminster, that would lead probably to, I mean, in non-controversial cases in which would that actually contribute to compliance as well? I'm thinking about the counter case, the case in which it's not that the Scottish want to promote more rights or the Northern Ireland wants to promote, the case in which it's pseudo-neutral to some extent, on that there is no political preference on whether complying or not. And if you think that in those cases, it would make sense for compliance for more of a unitarian state type of perspective, or if the devolution is going to impact as well. Thank you.
Yeah, thanks a lot. I really learned a lot from the panel. I didn't know much about how the devolution is impacting internally. And so my question for Nas and Stuart is whether there have been cases before the ECHR where there's different levels of protection nationally were raised. I'm thinking about two types of situations which is basically Asanidze against Georgia types of case where the court says, well, there cannot be this kind of regional take on jurisdiction. And the other one, which you made me think a lot, is Article 56 of the Convention, which is otherwise known as the overseas jurisdiction or colonial jurisdiction, which is has a provision under paragraph 3. It says the provision of this convention, so in overseas territories, shall be applied in such territories with due regard to local requirements. So this is a very exceptional type of language. There is not much there to explain what these local requirements mean. Does it mean enhancing, modifying, or reducing rights? But it made me think a lot in the context of devolution. I really enjoyed your presentation. I found it fascinating to learn how other jurisdictions have dealt with ECHR, and it was also the best way to conclude this event. So thanks for that. I was just thinking also within the European context, the ECHR has played this inspirational role as well. So in the context of EU, for example, when it didn't have the charter, it started using ECHR literally as an inspirational source. And it became kind of semi-binding in a way. And it was the same then in Bosnia and Herzegovina and Kosovo before joining it, that the treaty was part of the peace agreement and was this inspirational aspect there as well. And for Jasper, I'm very curious to know more, where do the judges and staff in the Netherlands learn about ECHR? So is it part of any training when they become judges and start working at the court, or where this is indeed in terms of resources very challenging? I teach in the Netherlands as well, and there is in Utrecht, for example, there is no mandatory course on human rights at the bachelor level. We have a week on public international law where we bring human rights, but that's it. So I'm very curious also, where does this knowledge come from?
Okay. That's
Let's take 2 more questions and then everyone can get 3-4 minutes to respond. Christy and Ed.
My comments or questions really for Stuart, and I'm sorry because I'm actually not sure if they if they relate to your paper. I think they kind of do, but maybe it'd be interesting to hear from you whether you think they do or not. So my first, in thinking about this fragmentation and the relationship between the devolved nations and the centre, was about whether the sort of safe access zones case in Northern Ireland, if that fits into your framework at all. And I was thinking about that being accepted in Northern Ireland and then being replicated in legislation elsewhere within the UK, in terms of thinking about where things are being determined and where they're being imported across. I'm not sure if it fits through the project or not. And the second was just to ask you about your thoughts on the new Northern Ireland bill, which again, I don't know whether it fits within the parameters of your paper or not.
Thank you. I'll just, if I can be permitted a comment just to start with, it's something we've not necessarily discussed over the 2 days, which is to say that the UK judges do take a very positive approach to their interaction with the Strasbourg court under Section 2.1 of the Human Rights Act, at least whilst that provision is there. They do take it very seriously and will follow clear and consistent lines of the Strasbourg jurisprudence, and will be very reluctant not to follow it unless there's a special reason. But so that's just a comment on, lest we're left with the impression that UK judges don't engage. You know, it's probably more the politician, you know, it is certainly more the politicians, I would say, which are moving on. Stuart, the cultural relativism point, I like that, but I'm wondering, is it culture? Does the cultural element really come through there, or is it more sort of constitutional happenstance or accident with the way things have happened? I reflect more generally on the Northern, a case I remember from a long time ago. I wasn't, you know, actually in academia at the time, but the Dudgeon v UK case is ironic here because that was a case in respect of which Northern Ireland was lagging behind the rest of the UK in relation to criminalisation of consensual homosexual activity. And actually, I think the records show the UK government was then quite pleased to have a Strasbourg judgment, which meant it could kind of force Northern Ireland into line. So kind of reverse, I think, situation of what we're seeing there. So the questions come along these lines. I'm wondering if what we're seeing here, and Naz's paper, Stuart's paper, about different approaches in the UK is relevant to the bigger, well, it's politically relevant, I see, to the question of UK withdrawal from the convention, because there's a, you know, suggestion, I think, that actually to the extent there is some support for the UK in the UK for withdrawal, it's very much just got a Southern England, London, Conservative voters, Reform voters thing, which doesn't have the same resonance, even though I see Reform is growing in Scotland, with Scotland and Northern Ireland, my impression at least, I don't know. So there is this issue, isn't there, a bit like Brexit, sorry to bring that up again, that, you know, a certain part of the country may be taking the rest of the country along on a certain path. So that's the general question I have. One last question, if I may, to Jasper. So what if the Dutch courts actually disagree with the Strasbourg jurisprudence? So there's scope in the UK court, when it's not clear and consistent, they're able to say, well, let's have a dialogue on the matter. I assume it's the same situation in the Netherlands, bar a circumstance when they say, well, we're not going to, you know, we would draw the line if there's a fundamental constitutional principle at stake, you know, we would be able to insist on our own position on that. I wonder how that is reflected or not in the Dutch national context. Thank you very much. I'll switch.
And I'll just use my power of chair to ask Adaena one question. So Adaena, I'm curious, really interesting presentation. Is the, okay, I'm not really getting how to frame it, but it basically is the reason that you see some impact of the ECHR in Europe, in Australia, the fact that there is some jurisprudential lacuna, there is no Bill of Rights, there's a culture of judicial restraint where you just can't compare it to the US, where if you want to do a decision that you want to do, blame it on the founders or be like, I believe in living constitutionalism, which means anything. Because you can't do that, this is like the easiest way to do human right adjudication. I'm just curious if that's the case or if there's some other reasoning to it. And we can start from your side of the table and then move here with responses.
I think that's a good question, but I think if that were the case, then the ICCPR would be more widely cited because Australia is a party to that. And going on what Jasper has said in his presentation as well, is that you don't see any of the UN treaty bodies cited in many of these cases. So I think there's something more fundamental about the jurisprudence of the ECHR. And I think, personally, I think it's the quality of the reasoning and how detailed it is. And you see that when you read these Australian constitutional judgments, they do go into a lot of that detail, and they look at all of the citations and they look at all of the case law. So I think there is something unique about the way that the Strasbourg court reasons. But I do think as well, like you said, this is a way to sort of plug the human rights protection gaps in Australia.
Just picking on that, I did my PhD also looking at New Zealand and then more in terms of human rights treaty bodies, and your results are exactly what is going on in New Zealand. So 4 times more references to the Strasbourg Court than to the UN Human Rights Committee. So that's quite surprising. And also reflecting on your piece, then I'll answer the questions. So I think one of the, I also rely on his quote very much in line with the shared identity of Anna Marie Slaughter is Justice Kirby, who served in the High Court of Australia from 1996 to 2009. And he said that while legal professionals once viewed issues through the lens of a nation state, they now approach contemporary challenges through the world's eye. So I think he was behind many of the references to Strasbourg in Australia, also indeed confirming what we both found, that the background and expertise of individual judges really matters. Okay, so now the questions. Yeah, what about in terms of a bit about the methodology in terms of the interviews? So in the Netherlands, we have 4 highest courts, so the Supreme Court and 3 administrative courts. What I did was first the analysis of judgments, identifying, let's say, various judges in terms of their involvement in the cases. And I wanted to have judges who have been, let's say, prolific, or at least who have been involved in judgments in which the Strasbourg Court was relied upon very much. Well, in the Netherlands, we don't have a common law tradition with dissenting opinions. So it's very difficult to get a grip on what an individual judge thinks. And most higher court judgments are in formations of 5. So it's very difficult to, let's say, determine, oh, this was this individual judge. But try to get a grip on, let's say, their involvement in the cases and try to select some sort of representative picture, even though the numbers are quite limited. I only interviewed 19. For the Supreme Court, the president of the Supreme Court simply decided which judges I could interview. So I simply, well, accepted that, obviously. Yeah, reflecting beyond the Dutch experience, that's a very good point. So that's something I have to develop a bit more. So I selected Netherlands, well, pragmatically also because I'm from the Netherlands, but I think it's a fair case in the sense of it's a most likely case. So you can really study the phenomenon, and also, well, I think it can really tell us something about, let's say, the court and treaty bodies as such. So if I would have selected a state which, well, let's say the capacity of courts is more limited, then I would come up more, let's say, state level factors. So I really wanted to say something about, let's say, the functioning and also the legitimacy of courts and treaty bodies at the international level. But I think based on what I've seen in similar articles, there's not that much of a difference between countries, and we shouldn't exaggerate also the difference between monism or dualism. That does not seem to be the more dominant explanation. Yeah, Kustreem's question about the how do judges learn that? Well, I think it's true that human rights courses as such are not mandatory at most universities. What we have is a mainstreaming of human rights in all bachelor courses. So criminal law in the Netherlands, it's infused with Strasbourg case law. So I know at least in Nijmegen, my colleagues teach about criminal procedural law and infuse that with a lot of Strasbourg and ECHR, and the same for constitutional law, administrative law, and perhaps to a lesser extent private law. So that, and I think I can't compare it with other countries, but we have this training center for judges, which is quite professional. And I also give indeed trainings. At least I gave a training on the EU Charter, but there are similar trainings on the convention. So I think in terms of university training, human rights get a decent attention, and also, let's say, past university courses are offered. So that makes, I think that they're very well aware of all these developments. And just one example, the highest Dutch administrative court, the Council of State, even has, let's say, coordinators for EU law and coordinators for constitutional issues, really, let's say, working on transversal issues for different chambers when a human rights or EU law issue is raised. And they really keep a close eye on everything that's what's going on in Luxembourg, Strasbourg. And then lastly, Ad's question, yeah, what if Dutch courts do not agree? So at least in the period I studied, and I think also the last 10 to 20 years, we haven't had, let's say, Hearst type of cases in which there was a violation against the Netherlands that Dutch courts didn't like or didn't agree with. So there were no, let's say, situations in which well there was this dialogue. I've seen it in terms of dialogue with the Luxembourg court following a preliminary reference and an answer that they didn't like, but not so much in relation to the ECHR. But in cases not, let's say, related to the Netherlands, so that I also discussed in interviews, and then I noted that Dutch judges were very happy with the fact of, or at least saw it as some sort of advantage that the case law of the court is so extensive and casuistic that gives them actually freedom to, let's say, pick and choose a bit. So, and they would argue, well, there might be a white raven that we really don't agree with, but then we just ignore it, and then nobody would really see it. So, because, yeah, it's a margin of discretion, etc., etc. So they would just, yeah, so there have been these instances, but outright refusals or explicit decisions not to follow, I didn't find them, at least. So thanks.
Thank you. Thank you for the questions, also for the comments about the Hearst. I will start with the Edward question about how to affect the stronger political alignments with or unification of the country. I think for any cases for the European Court of Human Rights, the communication is very important, even more the more ordinary one. And I select my examples from the outliers, but I think many judgments also, they are really technical things. They are really easy things. Maybe they were not executed for many years, but because of the sometimes just lack of the knowledge, for example, really easy things. Because in my traineeship, during my traineeship, I saw really easy things, technical things. For this reason, I think training, education, and that's kind of things at the lower level, it's really important. And for this reason, maybe how we are translating the judgment is important, because there is a government agency before the Committee of Ministers, before the Execution Department and the court, and it provides all the communication, because the court just publishes its judgments, but how they will identify the necessary measures, because as you know, the court just says, usually apart from the pilot judgments, there is a violation of Article 6 of Article 8, and then how these national authorities will decide. For this reason, I think for every type of the states, it's really important that this communication, because communication and asking questions in this relationship provide justification for the other state institutions. And this become more important in the devolved context, because Strasbourg Court giving, and then Minister of Justice and the Foreign Affairs has this knowledge, but there should be also a web of the relationship between the devolved nations. And I really believe the importance of this. About the Kusrim question, my focus in my research is more not the colonial perspective, but I can give some examples from the Netherlands, from the overseas countries, for example, about local requirements. Maybe actually not local requirements, but the problems faced these, for example, overseas countries. Because as you know, the Netherlands has, the Kingdom of the Netherlands has 3 overseas countries in the Caribbean, Aruba, Chuchara, I hope my pronunciation, Curaçao, and Saint Martin, and for example, in the UK devolved nations, they're all together. But in the Netherlands context, the European Netherlands is here, and the 3 of them, it's the Caribbean part. And for this reason, for example, they face different problems. For example, about migration, the European Netherlands faced the migration from maybe Ukrainian people want to improve. But the Caribbean parts, migration from Venezuela, for example. And then there can be need, for example, different problems and different solutions sometimes. And for this reason, I think geographical differences, sometimes cultural differences, it's really important, I think, to consider in the execution context. And I don't know now in my knowledge if there is any case about these regional differences about the UK, but I will search after my presentation today. And for my last question, I hope it's not about the leaving the convention system, all these discussions. I really hope, because the UK system is, I think, one of the really successful execution system, I would say. But I think also this pattern, the different level of protection is common also other many member states of the Council of Europe. For example, also the Netherlands, European Netherlands incorporated many human rights treaties. But for example, Caribbeans now discussing, for example, some of them considering if they will incorporate or not incorporate. I think also this is the issue for Switzerland between the cantons and for also other countries. But I hope for the UK is not the living. Yeah, I will just finger cross.
Hey, yeah, a lot of questions and less than 2 minutes to answer them. So I'll try and get through them all. In relation to the question of me kind of maybe eluding some of the more interesting questions and why the devolved government might be more supportive of human rights and whether that's a political dynamic, which you suggest it is, or a cultural one, I think it's probably both. And one of the proposed explanations, for example, for why Wales is doing what it's doing is that it is a direct opposition to backsliding by the Westminster government. So it is motivated specifically by that. So the reason why Wales has decided to do this is because the Westminster government is behaving the way it is. Now, that is cultural. That is a cultural aspect of Wales. It's cultural in Scotland because they're very different to the rest of the UK. And Northern Ireland has a very different culture to the rest of the UK as well. You can look at how they voted on Brexit. You can look at their acceptance of EU membership. You can look at their acceptance of more progressive policies. So there is both cultural and political dynamics at play. And I think you're absolutely right. I need to try and capture those as much as possible. Is it a pushback against devolution rather than human rights? It's both. I'm not sure it's one or the other. It's both simultaneously. The pushback against devolution is occurring via human rights. It's a conduit through which that's happening. But I see the UK government as killing 2 birds with 1 stone on that one. It doesn't like devolution. It doesn't like human rights. Well, the Tories don't. They don't like devolution. They don't like human rights. So why not do both at the same time? Win-win. In terms of cases before the ECHR pushroom's question, yes, we have seen lots of cases throughout history. So Northern Ireland emergency provisions, internment, lots of cases specifically related to that. So like in terms of divergences that happen on a regional level, we have seen cases go to Strasbourg. In terms of the more recent developments, we haven't, because first of all, there aren't many cases going from the UK to Strasbourg, as we've discussed many times. But also it's very recent as well. What I think would be really interesting to see would be an Article 14 claim emerging from this as a result of discrimination or disparity of treatment between someone in the regions versus England. Kirsty, excellent point. Really interesting point about abortion, and it really struck me during Naz's presentation as well, to specifically look at how Westminster had changed the law while Stormont was suspended, and to introduce more progressive policies. So it isn't just a one-way traffic, it's a kind of a two-way process that's actually happening. It's really interesting that you point out in relation to the safe access zones, when we look specifically at these issue of criminalization of the ending of pregnancies, which they introduced in 2020, I think it was, that is now being introduced in England and Wales through the crime and policing bills. So we're seeing more progressive policy adopted by Westminster and then kind of almost being trialed and then brought into the rest of the UK. So yes, absolutely. And it'd be interesting to see what happens with safe access zones as things get weirder with reform, etc. And then finally, in relation to Ed's point, is it a cultural element or constitutional happenstance? You're absolutely right about Dublin and Ireland and all of that. I don't think that I don't think that it is just constitutional happenstance. I think there is definitely a cultural element to it, and you do see that, you know, there is this cultural element that I mentioned, specifically about Northern Ireland, specifically about Scotland, and to a lesser extent Wales as well. So yes, I do think there's culture, but there is definitely part of it too. That's it. Trying to do it all. Sorry.
Thank you so much. And again, you can have a I think that I would like to give close. Yolanda, would you like to say something?
I think Katya had. You want to close the
Oh,
panel?
okay. I was just going to end with saying that, you know, thank you, everyone. And just before we go, Katya would share a couple of words to close the event.
Yeah, thank you. We'll move straight on to the concluding remarks. And that's all?
I think.
Yeah, it is. Thank you. We move straight to the concluding remarks, but I won't keep you long. We have had a wonderfully rich 2 days, and I don't even want to begin to sum it up at that time of the day. But I learned a lot. The papers and discussions were at an extremely high level, and I want to express my appreciation and thank you for this to all of you. A quick note on follow-up. We've been asked from various corners, will there be a publication? And I think there will be. The question is when, how, and in which format, and we'll discuss that between the organizing team, but we will definitely get in touch about this. And the doubts about this are not linked to the principle, but to the further follow-on. We have been discussing this, not this event, but this theme as a kind of project. It's the Constitutional Resilience Project, but the project doesn't exist beyond these discussions and this conference. And the conference was partly about the call for papers in particular, to see what's out there, what's the interest, what are people working on. So we will pursue this, but that obviously also links to the publication question. So watch that space, also get back in touch, even also if you haven't presented. Our call for papers had a huge response, also a huge response from outside Europe, which we shamelessly did not, apart from one exception, really, or two exceptions maybe, did not indulge in, but certainly that project has a dimension beyond Europe. But because this wasn't a celebratory anniversary event, we kept that not in the center. So we'll widen that project. So do bear that in mind and keep in touch with us. On a separate note, more housekeeping note, the feedback, you will be sent a feedback form, email, or you can access it also via the QR code. So last housekeeping point, if you're not heading off immediately, there's some of us heading to the pub. Same place as yesterday, the Riding House Bloomsbury. You probably should look around the entrance area for us, and we'll be there for a little while. So after or soonish, not at 10 o'clock, maybe we'll wake up here in 20 minutes, half an hour. So if you linger on, we walk over together. So, but that brings me now really to the close. I want to thank with my wholeheartedly all speakers, chairs, discussants for the participation in the event. My big class convener, Yolinda in particular, and my co-conveners at Amal, and the whole BK team, Liam, who has really been very welcome. But not just Liam, but more behind the scenes, Carmel, Bradley, and Rena. And thank you everyone, and do keep in touch.